HR Learning's 2-hour virtual seminar on how to conduct an internal harassment and bullying investigation to determine facts and minimize liability. My name is Stacy and I'm going to be your host today. On behalf of Crane HR Learning, I would like to thank you for being part of this event. Today's webinar will be presented by Dr. Susan Strauss. A few words about her before we begin today's session. Dr. Susan Strauss is a national and international speaker, trainer, consultant, and a recognized expert on workplace and school harassment and bullying. She conducts harassment and bullying investigations and functions as an expert witness in harassment and bullying lawsuits. Her clients are from business, education, healthcare, law, and government organizations from both the public and private sector. Dr. Strauss has conducted research, written over 30 books, book chapters, and journal articles on harassment, bullying, and related topics. She has been featured on television and radio programs, as well as interviewed for newspaper and journal articles. Susan has a doctorate in organizational leadership. She is a registered nurse, has a bachelor's degree in human services and counseling, a master's degree in community health, and professional certificate in training and development. We are honored to have Susan with us to present today's webinar. Before we begin, I would like to inform you of the program outlined for this training session. This webinar is for 2 hours. First, Susan will take you through today's webinar, highlighting the areas that would be covered, and she would then share with you her presentation. We would like to inform you that all participants, once part of the teleconference, have been placed on mute and will remain so until the Q&A begins towards the end of the webinar. It is for the purpose of avoiding discontinuity and for allowing the speaker to speak clearly so that everyone present can take maximum benefit from this webinar. We also request all to hold back your questions until the Q&A window begins. 10 minutes of time will be allotted for the Q&A, during which your questions will be answered. If for any reason you get locked out of this training session or teleconference, please follow the same procedure to join in again. Now that we're all ready to start, I request Susan to take it from here. Susan?
Thank you, Stacy, and greetings, everybody. Welcome to a very important webinar, and I'm coming to you from Minnesota. We have a beautiful fall day today. Conducting investigations regarding, well, any investigation is critical. Today, we're focusing on investigations of harassment of any protected class and bullying. So with that, let's go. That is my quick and dirty bio. Let's look at the objectives for today. Oh, also, just to let you know, I will be pausing periodically to take a drink of water. When I pause, I just don't want you to think we've been disconnected. All right, with that, let's go. So we're going to discuss, how do you know if an investigation is really necessary if you've received a complaint? We will identify the components of an investigation, as well as also discuss, how do you interview the accuser, the accused, and witnesses. Now, I will use different names for these folks. An accuser might be the victim. It might be the complainant. The accused might be, the accuser might also be the target. The accused might be the harasser or the bully. And witnesses, well, they're just good old witnesses. We'll differentiate between a formal and an informal investigative procedure, and that sort of ties in with the first bullet about whether a full-blown investigation is necessary. Then how do you draw conclusions? How do you determine credibility? In my work as an expert witness for lawsuits, this is a huge area that's missing. When I begin my work, one of the first things I do is I need to see a copy of all the documentation and the final investigative report. Well, investigation in my experience, is minimal. There often is no investigative report, and consequently, there is nothing related to credibility of those that are interviewed and conclusions. And those are extremely important tasks of the investigator. And then writing a formal report. Now, we don't have time to specifically address the formal report today. We do a 1-hour webinar just on writing a formal report, but I will be giving you a template for a formal report, and I will be intermingling some of the aspects of the final report. The main thing is document, document, document. So with that, what is a good investigator? Well, you've got to be able to think clearly and analytically. You've got to be able to sound authoritative and convincing to a jury. But you know, so often these cases, even though there has been a formal complaint that's been submitted to the court, they end up settling outside of court. So you've got to be able to sound authoritative and convincing to opposing counsel. You've got to be unbiased and impartial. Now, that said, we all have our biases. I'm assuming you all know what your conscious biases are, but we've also got unconscious biases. And they will ease their way in no matter what. They're just there. It doesn't mean that we're bad people. The unconscious biases have been around since evolution. It's built into our DNA. So you're good with people. And I'm going to assume that those of you that are on today are HR professionals. We may have an attorney or two, but generally you wouldn't be in the jobs you're in if you weren't good with people. How are your writing skills? And you might go, oh, come on, lady. I mean, we do have degrees. Well, I'll tell you why I say this. When I teach at the universities, I will be teaching oftentimes graduate students. Now, these are, people that are sometimes VPs, heads of their departments, and often their writing is atrocious. So please take a look at your writing. Do you use active rather than passive voice? Do you have good punctuation? How is your vernacular? When does one's paragraph start and the other one end? Those sorts of things. Do you use, I don't know if I said this, active rather than passive voice? So you will not be the only one reading your report, but probably somebody else in your organization. Certainly attorneys will be reading it, both your attorneys and attorneys on the other side. You will have the expert witness on your side and their side reading it. So it's a reflection not only on you, but on your employer. You've got to be able to gather facts and follow up on leads. I think that it can sometimes be a challenge, and you get better with it the more you do. And do you know harassment law, discrimination law? And you notice I don't have bullying law, and that's because there is no federal law against bullying. Now, there's a couple of states that have some anti-bullying laws, but interestingly, nobody can sue under them. So there is no legal requirement to conduct an investigation as it relates to bullying. However, it would be at your own peril if you do not. So with that, let's get going. A good investigator knows how to ask good probing questions, and sometimes this can be tough. You can't use euphemisms. You've got to use real words, and I find this particularly difficult when I'm investigating sexual harassment. Are you introspective? So can you read between the lines? Can you see holes in the story? Are you able to separate rumor from fact? Now, what you're going to be learning today is not how to conduct criminal investigations. No, we're talking about conducting investigations that are a violation of your policies, as well as investigations dealing with civil rights law. So if you get a rumor, it's okay. In fact, I like it when I get a rumor. So if somebody says, well, I've never really heard Joshua tell dirty jokes, but I know that's what everybody says. Oh, well, tell me who you've heard this information from. And you will get additional names. So those names then are additional witnesses for you. So you've got to separate rumor fact, but the rumor accompanied with the names is positive. Are you able to communicate clearly? Now, I've talked about that a little bit with written communication, but of course, verbal as well. And I'm going to assume that you all are good at that, again, because of the career you've chosen. And are you skilled and knowledgeable? Not only in conducting investigations, but knowing the law, knowing what your policies are, knowing what your procedures are. So these are some qualities to look for in an investigator. And I see on number 6, I've only referenced sexual harassment. That is an error. In fact, I need to get rid of the word sexual, but it's any harassment, any discrimination, and to be able to differentiate harassment from bullying, but yet you still need to investigate complaints of bullying. I'll let you read through this after the webinar. And then self-examination. Take a quick perusal through this slide. I'll give you about 15 seconds. Now, we know by research that when we do self-examinations that we usually grade ourselves better than others might. So this is not a valid, reliable instrument, by the way, but it just gives you an idea. What I would recommend that you do is that you give this to a coworker that you trust to be honest with you, and have that person give you feedback on these questions. Then I would encourage you to give this to your good friend who really knows you and ask them to give you feedback on these questions. See how you do in comparison to how they respond. So one of the first questions that comes up is, when do I involve legal counsel? I'm not going to go through these. Again, you can read after the webinar. Very often we have 2 legal counsels. They have a corporate counsel, and then you might have a employment lawyer. Now, generally, when we're talking about harassment and bullying, we're talking about the employment lawyer. Now, you will have to decide which to call, or if you call both. But generally speaking, it's your employment lawyer for issues related to the webinar. So what about using a lawyer as an investigator? And by the way, this is not using any of your lawyers. This is using a lawyer that is not yours for an investigator. Well, pluses are, they certainly are trained in fact gathering, right? They will definitely have a legal understanding, so they know how this will look in court. What are some of the minuses? Well, unfortunately, there's a ton of research that shows lawyers are not particularly liked or trusted. So if you have a lawyer then that's conducting the investigation, you might have employees that are less likely to confide in that person when they know it's a lawyer, and that then negatively affect the quality of information that you glean from the interview. Jurors tend to distrust lawyers who testify, and it does create lawsuit thinking. So these are just some considerations. do not use your organization's attorney. They will be seen as just a little too cozy with management. All right, so they're going to be seen as biased. They also then would not be able to represent you in court because of attorney-client privilege. And they would have to reveal confidential conversations. So let's look at whether or not you use one or two investigators. Well, with one investigator, obviously it's going to be cheaper, whether you're using an external investigator or an internal investigator. You only have the bias of one individual, and it will ensure consistency, right? What about two investigators? Well, one can be a reality check to the other. They can compare their impressions and corroborate evidence and stories. The jury may like it if you have two investigators that came with the same decision. You might want to consider having male and female investigators, and it gives gender parity to the investigation, but I would even go more broadly than that. Depending on the demographics of your organization, consider having someone that is of a different color, race, or ethnicity. Those are three different protected classes. Or someone that might be Muslim, for example, or someone who might be LGBTQI. You get the idea. You would want to, perhaps, if you've got a very difficult interview, but I want you to consider something. Let's say that you get a call from HR and they've asked you to come down to their office. And you say, oh, great, what's it all about? And the response is, well, why don't you come down here and we'll talk about it? Well, that's going to be a little bit difficult, right? So your heart might beat a little faster, your stomach might turn, and you're thinking, oh, brother, what's this about? So you already will feel a little bit of intimidation. So imagine that you walk into HR's office and there's not just one HR professional, but two. There goes an increase in your intimidation. Now, that may, again, negatively affect the quality of the investigation. Maybe not, just something for you to consider. And then, of course, there's the time commitment, which can be looked at from a couple of different ways. One, it's a time commitment because you've got two people now, whether it's internal or external, that are conducting the investigation. So you've got the time of two people. And it could also mean that you are minimizing the time to conduct the investigation because there are two people. Now, you also are going to have to determine, if you use two, what's going to be the role and responsibility of each person. Is one of you going to ask questions while the other one writes the answers? Are you going to take turns asking questions and writing answers? Is one of you going to interview half of the witnesses or all those that are involved in the complaint while the other one interviews the other half? Anyway, you'll have decisions to make with that. So what about internal versus external investigators? Well, with internal, it's less expensive, right? Because their time, therefore their cost, is absorbed in their salary. They understand the culture, the politics, and the players. It'll be quicker because they're there on campus. They will appear pro-management. I hear this all the time when I'm doing training on not investigations, but in general on harassment and bullying. People will say, why in the world do we have our own HR people do investigations? We know that they're going to be biased towards management. Well, that's their perception. We know that that's not true. So there is appearance of bias. Now, what about external investigators? Well, generally speaking, they have better skills. Why? Because they've done more investigations. They will be neutral. They don't know anybody there. You would definitely want one if you don't have any formal investigator or HR professional. You would use an external investigator if there is a complaint against a senior manager. Now, let me just throw in a little bit here. You do not ever want to do an investigation against somebody that's higher up on the rung of the ladder than you are. You'll be stuck between a rock and a hard place. So look at the hierarchy and who you are going to be investigating. And if it's somebody that's above you in management, bring in an external investigator. You would do this for extremely serious charges, such as maybe a fight, which would be under the auspices of your code of conduct / bullying, although we have no consistent definition of bullying, but that would come under your code of conduct. You might have a sexual assault, so you bring in an external investigator. Then it's going to cost you more, obviously. They will charge based on their credentials and experience. Sometimes the cost is based on your geography. Where are you located? They do not know culture, the politics, and the players. Therefore, they will be less biased because the internal person is part of the culture, the politics, and the players. The external person is not. But they have no established credibility. So you want to make sure that you vet them before you hire them. Now, why investigate in the first place? Well, this just makes sense, right? You want to reduce liability and you want to restore harmony. Now, let's face it, when there's been a incident of harassment, and I'm going to add, or bullying, the word gets out, right? People know that this happened. And so you've got people gossiping at the water cooler or over lunch or texting, and you get the idea. Yeah, you don't want any of that stuff going on. You want people to be working and have it be a harmonious environment. So what are the objectives of the investigation? Well, you got to identify all the people that are involved and the who. Now you also have to identify what, where, when, and how. You will gather information, and we'll get into that. You will determine credibility for every person you interview, and that's going to be required to draw your conclusions. You have to do both. Then you, as HR, will suggest an action. Management is the one that determines the action, but they will very often look to you for that guidance. Then you will be responsible to remedy the situation. And what am I talking about with that? Well, if the incident occurred, what are you going to do to make amends to the victim? And then what about additional training? What about your policy? Does it need to be tweaked? When was the last time you did a training on your policy, etc.? And I'm going to take a drink. Okay. So when do you not investigate, generally speaking? Well, when the behavior has stopped. And if the harasser or the bully acknowledges their misconduct. Because you investigate to find out what happened and to make sure it stops. Well, if the accused says, yeah, I did it, and I'm not going to do it again, then generally you don't have to investigate. But maybe the misconduct was particularly severe, or it included quite a number of victims. Then you're going to want to investigate. So what is a complaint anyway? Well, it can be any of these things. So most of these are pretty obvious, but I'm going to start with anonymous on the bottom. Let's say that you come into work in the morning and underneath your door is a complaint. We'll say that it's for sexual harassment because that's what we're hearing a lot about. And the complaint tells you in somewhat vague terms, but also tells you what happened, but it doesn't identify what department it occurred in. It does not identify the accuser and the accused. Well, you need to do something about it, but what? Well, this is what you do. When you don't know where it occurred, you call in all of your department heads, managers. You let them know that a complaint has come forward. You give them a copy of your harassment policy. You review the policy with them. You do a mini train, and you remind them of what management's responsibility is and what the complaint procedure is. Now, the complaint procedure is more than just who do you report it to. And that's something that's often missing in these policies. All it says, what I have found in a majority of them, not all, is if you find that you've been the target of X, Y, and Z, report it to HR, your manager or any other manager you feel like reporting it to. So remind them of their responsibility. Now, when they come to your meeting, have each of them sign in. You need their signature, not a check mark by their name, not initials by their name, but their actual signature. Now, if you do know what department or work unit this occurred in, then you and the manager of that department will do the same thing that I just outlined that you would do with all managers. So all of the direct reports to that manager will come in, they'll sign in, they'll get a hard copy of the policy, and the manager and you will do a little training, review what should happen, that kind of behavior will not be tolerated, etc. Then that particular piece that's written up by the manager, including what was during the meeting, that the hard copy of the policy was distributed, and the manager will take the hard copy, take a copy of the sign-in sheets, take a copy of the agenda and what was covered, and give you a copy of all of that for you to put in your HR file, and the manager will put it in her or his file. Now, notice that right above that, it says that you reasonably should know. That's what the law says, that you either knew about it or you reasonably should have known. And you might go, well, if nobody ever told me, how should I know? Well, let's look at the bullets before that. Should you know because of an employee opinion survey? Should you know because you observed something that was questionable? Should you know because of an exit interview? Should you know because of an offhanded comment? Should you know because there's been gossip? Now, you should know, obviously you would know if something was written or verbal, but you should know, including gossip, offhanded comments, etc. So you need to do prompt investigation. Generally speaking, we're talking 24 to 48 hours. The law says you have to take prompt action with a complaint, but they do not indicate what that means. They do require, however, that you do a prompt investigation. In fact, you're going to have to if you've got to take prompt action. You want to get in there and start interviewing while people's memories are intact. Now, even then, we know that
were not all that red hot in the memory department as as observers or witnesses. And we see that when police are interviewing witnesses to, say, a car accident. So we see different things. We project onto incidents who we are sometimes. Now, there might be legitimate delays. I got a call from an attorney to come and do an investigation. I think he called me on a Wednesday, and I said, you know, I'm not going to be able to do it until next Tuesday. And he said, well, that's right. And I said, well, that seems a little long to me to begin an investigation. And he said, well, in this case, it won't matter. So I trusted him. He was the attorney. So it was, 6 days. But there are some cases where you can't wait at all and you're going to have to start immediately. So you establish a time frame and you communicate to the accuser and the accused what that time frame is. And then be sure you get your collective bargaining unit as well. Now you're going to develop a plan and you'll decide who are you going to interview and in what order. You determine the questions ahead of time. You gather the evidence. Again, that's coming. I'll let you know. You gather documents and policies. I'll let you know what those are. You will review procedures. Make sure you follow your policy. And again, I notice more often than not that policies do not include procedures. All they have is a reporting mechanism, but they say nothing about what will happen following the submission of the complaint. Then you determine who needs to know and what do they need to know. And do you need to consult experts? Now, who would be an expert anyway? We're going to be talking about that as well. So what I do is for determining questions, I create 3 sheets of paper per person I'm going to interview. On one sheet of paper, I write questions. On the other sheet of paper, I write answers. And on the third sheet of paper, I just label it as other. Now, on each of those, you've got to automatically include certain things. Your name, identified as the investigator, the name of the person that you are interviewing, including what their role is in the investigation and what is their position in the company. What's the beginning time and the end time, and I've got this listed for you towards the end, beginning and end time, and where did the interview take place? And you put that on the top of each of those 3 pages. You write down as many questions as you can determine prior to the interview on your questions page. Then on the answers page, you put the answers to those questions. Now, obviously, you will not be able to come up with all the questions before you even conduct the interview, because answers are going to be an impetus for additional questions. So let's say question number 5 is written on your question sheet, and you put the answer to question 5 on your answer sheet, but in their answering of question 5, it causes you to ask another couple of questions. So on the answer sheet, when you've written down their answer to question 5, and you've got another 3 questions, I write question A, and I put the question and the answer. Question B, the question and their answer. Now that's what I have found has worked for me. The other sheet is going to be where you document their credibility, any observations, etc. And I'll be talking about this again. Now, who needs to know? Really, you've got to keep this pretty confidential. So the only people that will need to know is whatever your company policy is. So maybe your company policy is that the VP of HR always gets to know what's going on. I'm just throwing these out arbitrarily. Or maybe you've got both the accuser and the accused work in the same department, and so you are telling the manager, hey, I just want you to know I'm conducting an investigation of a possible violation of our harassment policy. You don't have to even tell the manager what all is going on, but you might want to say, I'd like you just to keep your eyes open on how John and Jane are along. All right. So this is what you're doing for the plan. Now there will be routine statements that you'll be making to everybody that you interview. One, you'll talk to them about confidentiality. And what that is, and by the way, you are documenting all of this. So you document that you talked to each interviewee about these issues. So for confidentiality, you are going to tell every interviewee that you cannot promise 100% confidentiality. You are going to keep it as confidential as you possibly can, but you cannot promise it totally. They, however, need to promise confidentiality. That's their requirement. That's just what they have to do. And you document what you told them, and you'll be telling every single person the same thing. Then you will discuss retaliation. Retaliation is illegal. In fact, it is the most common complaint that goes to the EEOC and has been for the last 6 years. You are going to be giving them a handout with sample retaliatory behaviors, which are included here. And you will tell them that they are not to retaliate against anyone, but no one is to retaliate against them. And if, in fact, they feel that they are being retaliated against, they need to come and inform you, because that will require an entirely new investigation. You will ask them if they are participating voluntarily. Now, you might think they're going, oh, yeah, right, this is just what I want to do. But you know what? I've never had anybody tell me no. Now, there's a reason for this, which we'll get to. You will provide the policies that align with the complaint to the accuser and the accused. You do not need to provide those policies to the witnesses. If they want to know, they can access them on your online portal. You will let everybody know that you are taking notes and why. So why do you take notes? There's 3 main reasons. 1, you take notes, obviously, to memorialize the interview, right? It's a record of the interview. 2, you take notes so that you can corroborate stories. And 3, you take notes to write your formal report. Then you will tell them who will know. And again, that is maybe only their managers. And even then, their managers don't need to know everything, because you want to try to keep it confidential. You explain the process and how they fit. Now, this is how it goes. Let's say that Mohammed has come in, and you're going to tell Mohammed, you know, thanks for coming in, blah, blah, blah. We'll get to what else you say. But you say, Mohammed, your name was given to me as someone who may have some information about a possible violation of our harassment policy. And that's how you word it. I'm going to say it again. Mohammed, your name was given to me as someone who may have information of a possible violation of our harassment policy. All right. That's what you're going to say to everybody. And then you make sure that people know that you're doing an investigation, but all it is a fact-finding mission. You've obviously not drawn any conclusions. You are just trying to find out the facts. And you let them know that you might need to talk to them again. So those are routine statements, even if this is to the accuser or the accused. And I always take my notes by longhand. I think it's rude, this is my feeling, about typing them up as you're talking to them. You've got the sound of the keyboard. People are looking at this. You end up looking more at the screen than you do at your interviewee. And I also use longhand so that when it comes time for me to type up my interview, I can use that as somewhat of a quality assurance tactic. Because as I'm typing up the questions and the answers, I might see, oh, I really goofed here. I should have asked about such and such and such and such. So I can call them up or call them into my office or whatever and ask them the other questions. Now, one of the things that comes up is, hey, can I record this interview? You don't need to record it. And the mistake that people make is, well, I don't have to take notes then. I'll just record it and that'll be enough. No, you have to take your notes. That's your documentation. That shows you investigated. Not only that, but remember why you take the notes. It's to corroborate evidence. It's to write your formal report. And if you only tape it, you're going to have to turn around and listen to the tape and take the notes listening to the tape. It's going to take you twice as long to conduct the interview. So I have never taped any of mine, and you don't need to. So when questioning, you start with easy questions. You get their background. How long have they worked here? What's their position? Who do they work with? What department? Do they like their job? Why? Why not? Questions about their department's climate and the organization's climate. You don't give them any more information than they need to know, and you differentiate fact from rumor. Now remember, hearsay or rumor is okay. You just have to separate the two out. So let's just take a little vignette, and so you can see how it goes. We're going to say Susie came in and complained that Billy was telling sexual jokes during lunch in the cafeteria. So you are going to check that out. So you did your routine statements, and now you're going to talk to Billy. Billy, thanks for coming in. You do your routine statements, and you say, tell me a little bit about your background anyway. Where did you work before here? What did you do? How long have you been here with ABC Company? And I think you're up in research and development, right? How long have you been in that department? And how long have you been in your position? Who all works up there? Who do you work with? What do you like about your job? What are some of the things you don't like about your job? Like working in research and development anyway. What's the climate like up there? How would you define the climate here at ABC Company? I understand, Billy, that you all are a pretty close-knit group up there in R&D, and that for the most part, you often end up having lunch together. Tell me about that. Oh, yeah, we have lunch together. We all get along real well. We all like each other. We like the work that we do. Well, what do you talk about anyway when you're having lunch together, considering that you talk, I would assume, even when you're up working? Oh, we talk about the usual stuff. We got some doggone quality improvement process coming down the pike. None of us are real happy about that. You know how that goes. And Mohammed, he's all happy now that this darn virus is starting to let up a little bit. He's quite anxious. He's got a trip planned to go to Kuwait and see his family. Joanna, oh my word, she's going to be a grandma for the first time. So we had to see the pictures of the baby with the sonogram, and we know it's a little girl. So can you believe it? She even brought in a couple items of clothing for this brand new baby girl. I got to admit, they are cute. They're so tiny. Well, what else do you talk about? Oh, this, that, and the other. Well, I understand, Billy, that you all like to tell jokes during the noon hour. Well, yeah, we do. You got to have a little fun here, you know. Well, what kind of jokes do you tell? Okay. Yes, I know. I ended up telling some dirty jokes today. Okay, we're going to stop right now on this little vignette, and we're going to come back to Susie and Billy later. But it gives you an idea of how this works. And I call that the funneling technique for questions. You funnel, you start broad and you gradually narrow it in. So what other questioning tips are there? Well, you use open-ended questions, not yes or no. And people are sometimes pretty nervous about it. And they will not always speak in chronological order. So you often have to say, well, who, what, where, when, and how, and try to get it in chronology. Okay? And you keep asking to help them talk in chronological order. You keep saying what happened next and what happened next. So you might have to clarify, I don't recall versus I don't recall. Now you're going to say, huh? What do you mean? Well, it might be I don't remember versus I don't remember. But let's say you're asking somebody about the jokes that were told during lunch. And somebody might go, oh, I don't remember that. Well, are they saying, you would say, well, are you saying you don't remember that because you just didn't hear it and therefore you don't know if it occurred? Or when you say, I don't remember that, are you saying, oh, you know what? He could have been telling dirty jokes. I just don't remember. Because there's a difference. There's a difference. I don't recall that at all compared to, he might have. I just don't remember for sure. So the interview for the initial interview will be for the complainant. Now, the complainant is generally the victim, but the complainant may, in fact, be a witness. So we've already talked a little bit about the routine pieces and what you're going to say to them. You will talk about honesty. You will ensure that the victim or the complainant knows if there's any retaliation, and if the behavior continues, and if they think of anything else following your meeting to come and tell you. Now, here are some sample interview questions. I'm not going to go through all of these. You've got these. You'll find them very, very helpful for interviewing the target. And of course, you'll be adding some of your own as well. Now, if you take a look at question 49, it says, what would you like to see happen as a result of your coming forward? So you're asking Susie this. Now, she's come to you and she has told you that this is the first time she's ever heard Billy tell dirty jokes. He never really has before. So she's coming to let you know, and you've asked her, what would you like to see happen? And so scenario number one might be, oh, you don't need to do anything about it. I just thought somebody ought to know. And she might even say, I want you to do anything about it. Well, excuse me, you can tell her that you understand that, but that you have a responsibility to follow through and to talk to Billy. All right, scenario number two might be, oh, you know what? I'll talk to Billy. Actually, he and I know each other quite well. We actually went to high school together, and we very often leave at the end of the day together and walk out to our cars in the parking lot. And you say, "Oh, okay, great. Do you need any help in knowing what to say?" And Susie says, "Nah, it's okay. I'm going to take a drink here." And you tell her to come in tomorrow morning when you're to work. Stop in my office. I just want to know how it goes. But then you let her know, I will still need to talk to Billy. Okay. Another scenario might be that Susie says, "I don't even want to go back up to work. I don't even want to work with him anymore. I can't stand it. I just can't stand it." Oh, now what are you going to do? It's during the noon hour. Susie's come down to talk to you about Billy, and she doesn't want to go back up to work. Well, fortunately for you, you don't have to make that decision. Management does. Whatever happens ever, make sure you do not move Susie. Billy's the one that's got to be moved. And why do you not move Susie? It's going to be seen as retaliation, potentially. Remember, retaliation is against the law. It's illegal. So if anybody has to move, it's got to be Billy. And that's something that the manager is going to need to be aware of as well. Now, what if Billy and C are both scientists? And let's say that they are working for a research company working on the COVID vaccine. The only two in the company that have the expertise. Now, what is management going to do? So you see, it's not always so easy. Now, if you look at the bottom of the page, we're going to be reviewing this again, but you will review the key points made by the victim. If you write well, which I do not anymore, you can have the complainant read the questions and your answers to make sure that you've captured accurately what she said. If you didn't, she might say, "Oh no, this part isn't quite right." Draw a line underneath the interview questions and have her either put the correction or you can put the correction. And then have her sign the correction. If she doesn't want to sign the interview notes, you cannot make her do it. And you can sign it and say, Susie agrees that the notes are accurate. Now, I always ask the complainant to please document what happened. I want to make sure that what Susie tells me, what I hear, what I write down, and Susie's documentation, that they are synonymous. So it's just a way to make sure all the I's are dotted and the T's are crossed. Then you'll look down, it says, make sure that the victim lets you know if there's additional information. Sometimes, now the Susie and Billy one isn't so much an example of this, but sometimes just talking about an event and then maybe a week later they'll go, "Oh, I totally forgot to tell HR about blah, blah, blah." And the interview itself, as it processes in the brain, will end up circulating and they'll have to come back and tell you. Of course, retaliation. And then what if the behavior, if you think that it could be criminal, let's say that Susie's breast was grabbed, well, then you will call the police. Now, it's going to be up to Susie whether she presses charges or not, but you need to call the police. You do not do a criminal investigation. You are doing a civil or policy investigation. You do not know how to do a criminal investigation. And you don't think, well, I'll call the police, let them come in, they can investigate. And if they say there's an issue, then I'll investigate. No, that doesn't work that way. Their investigation will be much different than yours. They may come out and say, hey, there was no crime here, whereas you will do an investigation and go, well, there was a civil issue based on your knowledge, and there was a violation of the policy. So you can't go by what they determine. You can also, now your attorneys will probably tell you not to do this, but you can also inform the complainant, in this case Susie, although telling dirty jokes wouldn't even qualify, but the complainant has a right to go to the EEOC or your state's Human Rights Department. Okay, retaliation. These are examples of retaliation that you will let the complainant as well as everyone else know. All right, now here are some additional retaliatory behaviors, and you'll notice these behaviors have a more critical effect on an individual because it affects their work. They could get fired. They may not get the kinds of work that they desire, and so that's the issue. What I want you to do now is to take the information on these last two slides, type it up, and give that as a handout to everybody that you are interviewing so they know. Now, there's another kind of retaliation as well, and it's called constructive discharge. And this is where people, could be the boss, could be other colleagues, make life so miserable for either the accuser or the accused, or even sometimes the witnesses, that it forces that person to quit. That is also retaliation. So, what documents need to be reviewed? Well, any policy and procedure that aligns with the complaint. So, for example, I got a call not too long ago to do an investigation of pornography. If you can imagine, the vice president of the company was sending porn to his direct reports and to some clients. I couldn't believe it. So first thing I do, of course, is get policies. Now, I had to get several because this involved a violation of several policies. Their harassment policies, for one thing, their IT policies. I think I even grabbed their social media policies, and I don't remember if there was a code of conduct policy I grabbed or not. But you review those policies and make sure that you follow the procedures and that the company has. What about union grievance procedures? The employee handbook and personnel files. The only personnel files I look at are the accused and the accusers. And what do I look at? Oh, I just look to get a general idea of the kind of employee they are. Do they get here on time? Do they ever work overtime? Do they go above and beyond? Have they been in trouble for anything? Do they complain a lot? That sort of thing. I do not look at the witness personnel files. Generally, it's not required. And then you want to look at emails and text messages and instant messages. I don't even know if we use those anymore. Voicemail, telephone records, home computers and other personal electronic devices, documents. Now, what documents would you look at? And this could be electronic and hard copy. Obviously, your policies and procedures, but you need to go on that EEOC website and your state's human rights website and download any documents they have that align with the complaint. Well, I know the EEOC has some wonderful documents dealing with harassment, even harassment of Muslims. You want to grab those, pull them down, and read them. You will be using these documents to draw your conclusions and write your final report. What about video and audio surveillance, social networking sites, But be careful, because the National Labor Review Act does have surveillance issues and privacy issues that need to be adhered to. Now, all of this is going to get documented, by the way. You will document all of the documents that you reviewed, and you will be documenting the policies, what was adhered to, what was not. What did you find in looking at the EEOC documents? What parts of their suggestions on sexual harassment did you adhere to? Did the company adhere to? This is a lot of work. So you might have to take some interim action. When? Well, there's been an assault or physical harm or even a threat of such. If the target is uncomfortable working with the accused, remember I said Susie doesn't want to work with Billy anymore. If the misconduct is ongoing. Now, why? Because you don't want that accused person to do anything else that's going to harm the target or other people. You want to protect the organization, and you want the accused protected. So now, tips for talking to the accused. So don't, whatever you do, put words into his or her mouth. Don't shy away from difficult questions. Don't be surprised of denial. You don't ever trick the person. Some of the questions for both the accused and the accuser are tough, and you might be embarrassed yourself. Now, if I'm not understanding, I try to paraphrase what any individual has said. And when I'm interviewing the accused, I might say, okay, now this is what I think I heard you say, blah, blah, blah. Did I get that right? And don't let me put words in your mouth. If I didn't get it right, tell me. Because sometimes they want to please you. And they'll say, oh, yeah, that's right. That's what I said. So anyway, these are the tips for talking to the accused. Now, what if the accused refuses to meet with you? Well, you've got to let them know that that's going to be taken into account when you're drawing your conclusions, because all you're going to have is the account from the accuser. And they need to know that they, in all likelihood, will be disciplined up to and including termination. I've heard judges in their written responses say that all policies need to include the idea that refusing to take part in an investigation can result in termination. So if it's a criminal allegation, you've got to let the accused know that they have a right to an attorney and they can call one then. And then you would call law enforcement. Now, there's such a thing as false imprisonment. This is when you, because you are the employer now, intended to confine the employee, now in this case, the accused. The accused knows it. They know you're confining them, and they're not saying it's okay. Now, this is true with anybody that you're interviewing, but right now we're just talking about the accused. So you've got to avoid false imprisonment. So how do you do that? Remember, in the very beginning, I said you ask if they are willing to participate. And you document that they yes. You meet in a neutral location when possible. I always try to meet in a conference room at the end of a hallway. That's not always possible. Sometimes people will tell me, because I'm an external investigator now, they will say, oh, you know what? You can use my office. It's at the end of the hallway. I can work somewhere else this afternoon. But when I do not sit behind the desk. I pull myself out so there is no barrier between the person I'm interviewing and me. You make sure that they have access to the door. And you want access to the door as well. If they ask to stop, you stop. In fact, when they come in, I let them know right away. Feel free to let me know if you need a break. Feel free if you need to stop for any reason, just let me know. If you want to get up and walk around a little bit in the room as we're doing the interview, that's fine as well. I also make sure that I've got Kleenex in the room, and I've got pop or coffee or sometimes chocolate chip cookies. And then document any unusual occurrences. The only occurrences that I've had to document is crying, and I do document that. Sometimes people sob, sometimes it's just tears. But this will help you avoid false imprisonment. Now, there is such a thing as defamation. This is a false communication that is intended to harm an individual's reputation by using public ridicule and contempt. Now, do you remember I told you in the beginning that one of the things you say when people are coming in to meet with you is, your name was given to me as someone who may have information about a possible violation of our harassment policy. I didn't bring them in and say, Mohammed, somebody told me that you know that Billy told sexual jokes and violated the sexual harassment policy. You never do that. You always speak in terms of the policy. So here are some tips to avoid defamation. Again, I'm not going to go through these. You can read through them after the webinar. Now, I want you to think about how the accused is probably feeling. First of all, they might be angry. Now, for crying out loud, what'd you bring me down here for? They might be worried. Oh boy, what have I done now? They might be indignant. What do you mean calling me down here for something like this? They'll be brimming with questions, right? Like who said, what was said and by whom and what's going to happen to me? And they might be defensive. So, allow some anger because it's kind of a common response. Now, they do not have the right to be abusive to you, however. And if you feel that they are, quote unquote, bullying you or being disrespectful to you, you've got to call them out on it. And you would say, Billy, when you talk to me with that tone of voice, and I see anger in your facial expression, that's not okay. So I'm going to give you a choice to either treat me with more respect or we're going to end the interview. And you set the boundaries. I've never had to do that. Hopefully you won't either. So when interviewing then the accused, you do not ever reveal the names of other people you've interviewed, and this includes who the complainant was. They do not get to know who complained about them. They might figure it out, but that's something different. And you do not discuss your personal opinions. Now, this is true when you're interviewing anybody, but it's the accused that usually wants to know. And you do not insult the person being interviewed. All right, now here are tips on interviewing the accused. We've talked about a good share of them. You are going to tell the accused that they are not to discuss this with anybody, that they are not to confront who they think is the complainant. And then that's more tips. And here are some sample interview questions for the accused. Now, you don't have to be a jerk to this person. Remember, you are on a fact-finding mission. I'm going to take a drink. You can empathize and say, I can tell you're feeling sad here. I can tell you're angry. I can tell you're upset. And I know this is hard to talk about. I know that you're uncomfortable with this. But remember, you don't know if they did this or not. All right? So I think you'll find the interview questions helpful. Now, one of the things that comes up is, should I interview the witnesses before I interview the accused? I always used to interview the accused before I interviewed the witnesses. I don't do that anymore. I interview the witnesses because I want to know what they saw. Because sometimes the accused will say, no, that's not true. And if I've already interviewed witnesses, then I can respond back to the accused, because you have to push back then and say, well, I've heard from 3 other people that you did do X, Y, and Z. Are you saying that they are lying? And very often what I'll hear back is, well, no, they may not be lying. They just see it differently than I do, or they just heard it differently than what I said. But you do have to push back. You do have to confront them. You don't always have to take everything at their word. Now, there is such a thing as an informal resolution. So what is it? Go ahead and peruse this slide. Now, if you look to the left, formal procedures, that's what today's webinar is all about. On the right is informal. So I'd like you to start in reading the informal so that you understand what it is. And I'm going to give you about a minute to peruse through this. Okay, not every single complaint requires a full-blown investigation. Let's go back to Billy and Susie, our little vignette. Susie complained about Billy. You've called Billy in, and he's admitted. Now, Susie says Billy's only told dirty jokes. The only time she's ever heard him do it was today. So you've called Billy in, and he admits that he's done it. There is no reason to do a formal investigation. It's been a today thing. It's not been anything egregious. It's been merely telling dirty jokes. Not okay, of course. It's against policy. But he's agreed that he's done it. He says he won't do it again. So in talking to Billy then, I will talk to him about it, and I will give him a copy of the policy. I don't think it says that here. And I will say, Billy, I want a commitment from you that this will not be repeated. And Billy says, no, I will not do it again. You document all of that you had this meeting with him, what you said to him, how he responded, that you got a commitment from him, and you give him the policy. Now, when this gets all documented, you will file it in a locked drawer in HR. Now, this informal procedure is something that every single one of your managers needs to know how to do. And those managers need to document it. The managers then send a copy of that documentation to you. You file it away. There has to be a single repository in every organization that keeps track of all these informal resolutions. Because the law says that if, in fact, you did not prevent behavior like this from becoming sexual harassment, you will be charged for liability. Well, you've got to keep track then of any informal responses, because you've got to intervene with these informal responses so it doesn't rise to the level of being illegal sexual harassment. So if in fact you go to file away this informal complaint, and you go to file it, and when you look in the file, you see that there are some other informal complaints documented by managers about Billy, now you as HR are going to have to get involved, because it might be teetering on illegal harassment, because it might be pervasive. Okay? So, who is a witness? Well, it's anybody that the target and the accused identify. So anyone with knowledge. Now, that could be co-worker, supervisor, family members? No, wait, how could family members be? But they can be. How might that work? Let's say that you have been sexually harassed by Billy today. He told some very, very nasty jokes. You go home, and who do you live with? I don't know, might be a spouse, might be a brother or sister or parents or a roommate, whoever. You all sit down to eat and you talk about your day. And you would probably end up saying, well, guess what happened? And you tell about Billy and his dirty jokes. Those family members then can testify, well, can be interviewed by you and can say, yeah, she came home and told me all about it that day. So it can attest to the date that they were informed. And these are not character witnesses. All right. So here are tips on interviewing witnesses. It's basically all the same stuff. You do your routine statements about being honest, about retaliation, and so on and so forth. And here are sample interview questions for the witnesses. Again, I think you'll find these very helpful. All right. Now, here is a thing on taking statements. I do not use these. I do not like them. And I don't think there's any need for them, because we've got the phone, we've got FaceTime, we have WhatsApp, we have Zoom, so that you can personally meet with people. People, I've had to read people that have written statements, and they use acronyms, and their writing isn't good, and you can't ask questions. They're not effective. But I'm giving it to you anyway, because you may find that somebody has written a statement, but they do it incorrectly. So after interviewing, you date and sign all of the documents. Remember, I gave you those three pages: questions, answers, and others. And I guess you document the start and end time, you identify who you interviewed, where it was, each question asked, each answer. You have that review for clarity or accuracy. You review it for clarity. Now, again, if you write clearly, that'll be great. Otherwise, you might have to have them take a look at it once you've got it typed up. So the interviewee will evaluate for accuracy. They will sign and date. Remember, you cannot require it. So you could sign and say, the interviewee reviewed these for accuracy and agreed they were accurate. But you document on that, quote, other sheet, the third sheet, relevant observation, credibility, and this is about documentation. So we're going to talk about documentation. All right. Now, you can read all of this. This gets into credibility. Now, this is just a quick and dirty, but here is credibility. So, main thing is you want to make sure you know to believe. And by the way, it's not about eye contact. It's not about somebody not fidgeting. I've been doing reading on how when people lie, and interestingly, people who are lying are more likely to have good eye contact than those that aren't. And fidgeting can be just something to do, or it could be nervousness. And just because someone tells you something that might not fit with what somebody else says doesn't mean they're necessarily lying. It just might be what their perception was. In the research that I've read, it said most of us are terrible at determining who lies and who doesn't. The only people that were even halfway decent were Secret Service agents, and that was only about 65% of the time. This was in one study. So lawyers, judges, investigators, we're not real red hot at it. So these are some of the things that you would want to assess for credibility. So you are going to document which of these bullet points you use to determine credibility for each person, but you will give a rationale for it. So, for example, the fourth one from the bottom, plausible. Is what they say plausible? Is it something that makes sense? Or is it just out in left field? One investigation I was doing, I could tell that the accuser had a mental health problem because his story was, it was bizarre. Now, I happened to also be a nurse who used to work in psych. That was years and years ago, and I am not a qualified expert for any of that, but I do recognize it. And in my expert report, I could not draw on my nursing and working psych in my expert report, but I didn't have to, because in talking to all of the witnesses and in talking to the accuser, he was sick. He was sick, and I couldn't say sick either. And I couldn't use a word like paranoid because that's making a diagnosis. So I had to describe what he said and then describe how that was not credible because it wasn't plausible. So you've got to be very specific in giving the rationale for these bullets. Do you have to include all of these bullets in your documentation? No, but select the ones that you think are the most credible, so that if in fact you are in a witness stand or being deposed and that opposing attorney says to you, well, why did you believe Susie and you didn't believe Billy? You can say, well, these are the reasons, bing, 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 and you talk about whatever bullet points fit and the rationale under each bullet point. All of that has to be documented. Yeah, it takes a lot of these reports and do all the documentation. So good documentation is this. Now, when you look at it, we're talking about either observable, but it's all objective. Sharon said blank to George. Jill was told if she didn't have late night meetings with Derek, her boss, she would not get her raise. On such and such a date and such a date, Bob pinched Diana on the buttocks and said, these are all either observable, but they are objective. And that's how you need to document. Poor documentation. Pat disrupts meetings. with offensive comments. What in the world does that mean anyway? What's an offensive comment? Anthony harassed. What's harassed mean? Trisha is lying. How do you know? What does that mean? Jack is a jerk. Never apply a label. So how would these be turned to good documentation? Well, you could say so-and-so and so-and-so state that Pat is disruptive in meetings by making the following types of offensive comments, : bing, bing, bing. Trisha is lying? No, you'd say so-and-so and so-and-so, which would be two witnesses, believe that Trisha's rendition of the incident, or you could say Trisha's rendition of the incident is in direct contrast to the three witnesses, so-and-so, so-and-so, and so-and-so, in the following ways. Bing, bing, bing. Anthony asked Ed. No. Anthony grabbed Ed in the buttocks and said, come on, sweet cheeks, let's go for that drink. Jack is a jerk. No. Two of Jack's co-workers, so-and-so and so-and-so, state that Jack is a difficult co-worker to work with for the following reasons. Bing, bing, bing. So you've got to get that objective aspect in there. So I've given you some more information on creating documentation. So you make a determination. What happened? Can you even determine what happened? And was there a violation of the policy or the law? Now, technically, you cannot determine if there's been a violation of the law. Only the jury can do that. Even as the expert witness in writing my report, I can't do that. Okay? So you review all the evidence and you make a determination. So this is what you can read following the webinar. So you've got to reach conclusions. Did it occur? Was it harassment or bullying? Was it severe? Was it welcomed? How often did it occur? What was the relationship between the two people? What were the effects on the victim and on the environment? In what kind of context did it happen? And was there an adverse action against the victim? So here is a list of bullet points on reaching conclusions. Again, do you have to use every one of these bullet points? No, but you want to use enough of them so that you are secure in your conclusions. Now let's look at some of and you identify the bullets and you give your rationale. All right? Let's look at this. Do not be afraid to make a judgment. You've got that responsibility. Could you be wrong? Possibly, but almost always there's a truth with he said, she said. And generally only 5 to 10% of investigations are inconclusive. And often you can go back and re-interview and see if it helps. Now, what helps in making the conclusion is which one of these two do you think applies to your investigation? You have to decide. Do you have to prove beyond a reasonable doubt? Or do you need a preponderance of evidence? And what in the world does a preponderance of evidence mean? A preponderance of evidence means that you would make this statement. More likely than not, the incident either did or did not occur. 51% evidence shows it did. But if you say more likely, based on a preponderance of the evidence, and you list the evidence, my conclusions are that Billy did blah, blah, blah. Okay? You do not prove beyond a reasonable doubt. That's criminal. That is in the courtroom. That's not this. It's a preponderance of evidence. So be sure you know your federal and state laws. They are changing all the time. Stay current with them. Title VII encompasses almost all of these as well. And like right now, the Title VII with race, ethnicity, and color, using the N word one time, once, and you can be liable. You might be looking at Title IX and saying, well, what's that on here for? Isn't that about sports in schools? No, it's about sex equity in schools, but it is also used in the Affordable Care Act. So I don't know if any of you are in healthcare or if you are in schools. Be sure you stay current. It is LGBTQI that is now illegal based on federal law. Genetic Information Non-Discrimination Act. You've just got to stay current in this stuff. Age discrimination is going up. Disability role is COVID playing in the ADA. And often this is based on your state, not on the feds. So be sure you're current on your state and your city. All right. So let's define sexual harassment. I'm sure you just as soon throw up as to look at this definition again. But when you look at it, and I would bet you've got this in your policy, look at the ambiguity of these guidelines. What is a sexual advance? What is a sexual favor? What is verbal or physical conduct of a sexual nature? What's a sexual nature? Very vague. So what's happened is when we have the cases go to court, we now know a little bit more about these things. So is the behavior, now this all gets documented, is the behavior welcomed? How do you know? Document. Is the behavior so severe and or pervasive that it interferes with an individual's ability to do his or her job and create a hostile work environment based on a reasonable person, victim, or woman? And is it sexual and or gender based or based on any other protected class? Now this is a lot. There's a lot on this screen. So let's go through it. On welcome, people will sometimes go along with the behavior because they don't want to be labeled a prude. But you've got to find out, was it welcomed or not? So even if you see people joking around and there's got what you would think of as quote unquote flirtation, well, you know what? You're going to have to ask the person on the receiving end. Tell them, you know, I saw you and so in the hallway today, and what he or she said to you, I just want to know, how did you feel about that? And they might say, I was embarrassed and I didn't like it, even though they went along with it. But that's something you've got to check out. Was it, now this is the part, was it so severe and or pervasive that it interfered, we're going to use Susie, with Susie's ability to do her job and create a hostile work environment based on a reasonable, now the name of the actual legal standard is reasonable person. But in the courts, it sometimes becomes a reasonable woman or reasonable victim. And was it sexual and or gender based, or was it based on any other protected class? Now, I would encourage you to do, first of all, I don't know when the last time was that you've taken a class on harassment so that you're current on what's going on with case law. It's important that you do. The severe and or pervasive, even the words offer ambiguity. Please go in, Google, and read up on it so you know what it means. Read up on what is a reasonable person, because even attorneys struggle with this, and certainly juries do. when we talk about sexual, that we're talking about your overt, typical sexual kinds of stuff. Same with the protected classes. But what do we mean by gender-based? Or it might be race-based or disability-based or religious-based or age-based. This is where you've got the intersection of bullying and harassment. So let's first of all take Billy. And Billy, will say, has been telling some dirty jokes off and on for about a month. First of all, is it unwelcomed? Yes. Is telling a couple of jokes a week over the course of a month so severe and or pervasive that it would interfere with a reasonable woman, because that's Susie, a reasonable woman's ability to do her job and create a hostile work environment? And was it sexual? So first of all, it was unwelcome. Second of all, it was not so severe and or pervasive that a reasonable woman wouldn't be able to do her job. Now, Susie might find she can't do her job, but it's based in the courtroom on a reasonable woman. Susie may have some heightened sensitivity to it. And that has to be examined by you as HR when you do your investigation. And is this a violation of our policy? But if it ever went to court, it would be based not on Susie, but on a reasonable woman. We know that there are some people that have heightened sensitivity to certain actions and comments that the reasonable person would not. So in this case, while what Billy is doing is a violation of your policy, it is not illegal. Now, the same would be true if, let's say, Billy is telling race jokes or age jokes or disability jokes. They would also have to be so severe and or pervasive that it would interfere with a reasonable victim's ability to do their job and create a hostile work environment, because it would be based on their protected class. Now, let's say that Billy does not tell any sexual jokes. He does nothing overtly sexual, nothing at all. But you know what? He's a bully. And he only bullies people of color. That's all. And so when he sabotages their work or bumps into them, quote, accidentally in the hallway, does not acknowledge their presence in meetings, does not say good morning to them, does not hold the door for them, for example. All of the bullying occurs only to people of color. Then it is not bullying, but it would be people of color-based harassment. So it is always at your own peril that you do not investigate complaints of bullying. Even bullying alone, maybe it's not based on anybody's protected class. Bullying has huge negative ramifications, as does harassment, to the workplace environment, to the witnesses, and to the victim. It's got to stop, even if it's not illegal. But harassment is illegal. So let's look at that. Let's say that Billy is just plain old bullying people. It is unwelcome. It is severe and or pervasive enough that would cause any reasonable person to just not like it at all and create a hostile work environment. But it's not harassment because the bullying, however you define it, is not occurring to people in a protected class. Even though it's severe, even though it's pervasive, even though it creates a hostile work environment, because it's not based on a protected class, it is not illegal harassment. Now, this is called this is called the hostile environment part of the law. And I think every policy I've ever looked at includes this in it. And then I hope that yours would give examples. Now, you've got another protected classes, as I mentioned before. Federal school. Now, this is what gender harassment is. It's a combination of sexual harassment, sex discrimination, and abuse and bullying. But the harassment is covert. It's not your typical overt. It's more covert. But that constitutes gender harassment. Gender-based harassment, but you can have race-based harassment, disability-based harassment, and of course that would be based on disability discrimination, disability harassment. Now, gender harassment, then, you want to be aware of it when you've got, it's a type of hostile work environment. So when somebody comes to complain about bullying, look at what unit they're in or your workplace at the environmental context. What's the gender type of the organization, the gender composition of the work group, and in general, what's your organizational climate or the departmental climate? Because those would be warning signals. Now, there's also quid pro quo. Whoops, I guess I didn't make a slide for that. Quid pro quo, trading this for that, tit for tat. It is absolute liability one time, and it's illegal. So it would be Derek saying to Jill, have night meetings with me, and you will be hired. You won't be fired. You will get a promotion. You won't get a raise. It's always trading this for that. Date me, and I'll make sure you get that promotion. If you don't date me, I'm going to fire you. One time, because it always involves a person in power over you. Now, remember, I said bullying is not illegal, but there are these other tort laws, and attorneys are getting smart. And there are times when, quote unquote, bullying can fall under any one of these tort laws. Now, mind you, harassment can also fall under these tort laws. Now, you would think bullying of itself would be an intentional infliction of emotional distress. This one is extremely difficult to bring into the courts. It's got all sorts of requirements for it to be illegal. What I testify to is negligence. So negligence is almost always part of harassment, but some of these others are as well. So keep in mind that everything we've talked about today ties into social media and all of your IT stuff. Now, if the complaint is not substantiated, this is what you're going to tell the accused. Go ahead and read it. Now, this will be documented, and it will be placed in the final little summary that goes into both the accused and the accuser's personnel file. But it will also go into your entire investigative file, which is in a locked drawer in the HR office. So you do follow-up action. Got to let the accused and the accuser know what the outcome was. And you include this information when telling them. Remember, you don't say who you interviewed. And you document their responses. So what actions need to be taken regarding the victim? What about the harasser, the bully? What about follow-up training? And what does a manager need differently than the rest of the employees? How are you going to heal the workplace or the department? What about the harassment policy? When was the last time that it was edited? When was the last time that it was actively disseminated? And this means more than just sending it out in an email. This means where a manager will take and distribute the hard copy to each of her or his direct reports, review the policy, and let people know what the expectations are of their behavior. So you've got to make the victim whole. What are some ways that you do that? Here are some examples. EAP stands for Employee Assistance Program. If you don't have it, then you should offer the victim X number of counseling sessions. So what's appropriate discipline anyway? You've got the harassment stop by law, but you've got to make the bullying stop as well. You've got to make sure that neither one of those recurs. So ask yourself this question. Disciplining. You've got to make the harassment stop by law. Now, you should make the bullying stop, even though it's not a legal requirement. So these are some of the questions that you would need to ask yourself. I'll let you read them. Now, this third one, if you've done an investigation and you have found that we'll say the CFO had sexually harassed or racially harassed or harassed anyone within the company, and that person was disciplined. Now you've got a maintenance worker who did the same thing. That maintenance worker's discipline needs to mirror the same discipline as somebody that was in the C-suite. So these are some of the questions you need to ask. And here are some examples of corrective action that you can take. Now, be a little bit careful with apology. I would say if they're going to apologize, that they should do it within the room. If they want to do it in writing, that's okay. Here's what I have found on occasion. That we'll say Billy will go to apologize to Susie, but then he'll add, well, you know, I never would have done this if you hadn't told me a dirty joke the other night at so-and-so's party. So the apology is there, but then there's the but part of it, and they end up turning it around and blaming the victim. So you don't want that to happen. Do you tell the victim the consequences to the harasser? I would ask your employment lawyer what they want you to do. Some lawyers I've worked with have said yes, others have said no. If you don't tell, there is this cloak of secrecy, particularly when the harasser continues to be employed. And so then morale gets lowered. People wonder, did anything happen or what? There is the rumor mill. The victim, though, does get better closure if they are informed. So you've got to monitor the environment. You have to have purposeful meetings with the victim. Now, this means this is more than just seeing somebody in the hallway and saying, hey, how's it going? It's got to be purposeful in your office, and you document it. How is it going? Has the behavior stopped? Has there been any retaliatory behaviors? So those are the two things you've got to ensure. And assuming, or depending upon the answer you get, then you might have to have a meeting with the accused as well. So be sure you follow up. And here is everything we just talked about. This is the follow-up. And you can do an appeal. Now, they can appeal only if there's new evidence. You can't appeal just because somebody doesn't like the outcome. Here is the template for the final report. All right. And like I said, we do a 1-hour webinar on this. I've talked about it a lot, though, about all the documenting. So the investigative file is going to include everything. And by copies of, documents, we're talking copies of whatever policies you utilized at this time for this investigation. You're going to include copies of any documents that you downloaded from the web, particularly from the EEOC website. And all of this goes into a locked file in HR. Now, in the appendix, still part of the file, you include these other things, copies of all those documents, investigational concerns. In this file, you will have all of your handwritten notes. Now, remember, everything is discoverable. And then you will have all of your notes as well, both of them. Now, you will do documentation of the accused and the accuser's file. And this is what you'll write. It's very simple. Nice and simple. Now, I've just added some other for you to read as just additional handouts. And that's it. So, as you can see, conducting investigations and documentation is huge. It's time consuming. It carries a lot of weight, not only in terms of liability, but in terms of morale in your workplace, trust of you, trust of management, turnover, absenteeism. And it's a huge responsibility that you as HR hold. So with that, Stacy, let's open it up for questions. Okay?
Susan, for that wonderful presentation, and also all the participants for cooperating with us. It's time we need to begin, and we request all who have questions for speaker to click on the raise hand option, which is a palm-like icon at the bottom of your participants panel, to ask your questions verbally or post your questions in the Q&A panel so that our speaker can read it out loud and then answer. For any reason, if you're unable to ask a question using either of the two means I mentioned, please share it with me by chat and I shall pass it on to our speaker to answer it. Meanwhile, we sincerely request you to share your feedback in the feedback form that will appear on your screen in the polling panel right now. The feedback form has just 8 questions, mostly multiple choice in nature, and it wouldn't take more than 2 minutes of your time to answer. The polling will remain open till the end of this session, and you can answer it even after the Q&A is over. We would be grateful if you could stay back a little longer and complete this feedback for us.
Oh, there's got to be some questions, I hope. No questions?
Attendees, it is time for the Q&A to begin, and we request all who have questions for speaker to click on the raise hand option, which is a palm-like icon at the bottom of your participants panel, to ask your questions verbally or post your questions in the Q&A panel so that our speaker can read it out loud and then answer. For any reason, if you're unable to ask a question using either of the two means I mentioned, please share it with me by chat and I shall pass it on to our speaker to answer it. Bill Williams, I see that you have a question. You can ask your question directly to Susan.
Yes. I was just wondering, is there a collection of templates that can be shared or have us pointed to that we might be able to go to, or can you share the slide deck that we saw today?
Yeah, Stacy, can you address? They should have all received the slides.
Yes, Susan. Attendees, the handout has already been sent to you via email, so I would request everybody to check in your spam and junk folders once in case if you don't have it in your inbox. If you don't have it, we will definitely forward it to you again after the session. Susan, I don't see any other questions coming in.
Okay, well, if you're like me, after I sit in on one of these and then I go to bed at night, I think, oh, shoot, I should have asked such and such a question and I didn't. So if, in fact, that might be true for any of you, please feel free to contact me. My bio page has my email, or you can contact me through Train HR, and we can set up a phone meeting. And I hope that today has been useful for you, that you were more than satisfied, and that you've learned some things. In the meantime, I know we still are not safe with this doggone virus, and I hope that you all are safe and well, and I hope you have a good rest of the day and a good week. So thank you so much for joining us, and Stacy, thank you as well. Have a good day, everybody. Bye-bye.
Thank you, Susan. We're grateful to all of you for having taken part in this webinar. If you would like to get in touch with us, you can send us an email to webinars@trainhrlearning.com. If any of you feel that your team members, colleagues, friends might benefit from this webinar, we are happy to inform you that it will be available in the recorded format and can be purchased from our website, or you can call us at 1-800-385-1627. We welcome your suggestions and feedback or ideas on how we can improve webinars. If you would like to suggest a topic or design a customized corporate training online or on-site, we ensure that whatever is a training necessity, it will be our priority. We look forward to having you with us again sometime soon, and thank you for your continued patronage. On behalf of our speaker, Susan Strauss, and the Train HR Learning team, I would like to say thank you for participating in this webinar, and we wish you a pleasant day ahead.